Hello, everyone. Thanks for coming back to the LawyerVid channel. It's very much appreciated. Your support is always welcome. Please subscribe. If you're interested in the LawyerVid platform, please go to lawyervid.com. And if you're an attorney, please go to lawyervid.com, sign up, create a profile, make yourself available to members of the general public throughout all 50 states for online video consultations. Now, the purpose of LawyerVid is obviously twofold, trying to make attorneys more accessible for members of the general public, a one-stop place where they will be able to search an attorney and right away, immediately through the platform, schedule an online video consultation. And the other portion of the usability for this platform is for the attorneys to get more business. We want to help attorneys grow their practice. We want them to get more exposure. We want them to have better marketing. However, aside for just talking about the LawyerVid platform on the LawyerVid channel, there's much more to it. It's not going to be a constant, a perpetual discussion of attempting to get people to visit the platform or attempting to get attorneys to sign up for the platform. The day will come where attorneys are signing up, and it'll be a fantastic day when I see that the platform has hundreds of attorneys that are signed up and thousands of people are going to the platform to, use it for its intended purpose. That'll be a great day, but that's not the entire purpose for the LawyerVid channel. So I just wanted to sort of clarify that point because, as I said in the first video, I've been practicing law for over 10 years. So I have significant experience, and I'm also very blessed that in my experience, I've been able to practice numerous areas. I've done quite a bit of criminal defense. I've done family law. I've done business litigation. I've done civil litigation. I have done driver's license reinstatements, traffic, DUI matters. I've helped people in ADA compliance issues. I've helped people with the Illinois Department of Human Rights and other administrative bodies that have to do with human rights. I'm very well versed in a number of different practice areas. So I look forward to actually talking about certain things in my practice, certain experiences that I've had in my practice. And I think that more to the point is that the LawyerVid channel itself, in addition to trying to have people actually use the LawyerVid platform and sign up, I want for people to be entertained. I want for people to visit this page, visit this channel, and find it entertaining in one way or another, humorous, interesting, whatever it may be. Maybe they think that the stories are fun. That's the goal. So in addition to the platform itself, it's a piece of it, but it's not the entire piece. So with having said that, what I wanted to talk about today was a little bit about some experiences that I've had with criminal defense and representing clients in criminal defense cases and questions that people always bring up and things that are always brought up when representing the client or people that are just inquiring with me just out of their own curiosity whenever I, discuss a particular case that I find interesting with them, or they ask they ask just in general about my practice and how I operate. So what I wanted to talk about today was to plea or not to plea. Now, this is a question that comes up all the time because obviously when a person is arrested and they're charged with a criminal violation, whatever it may be, it could be anything as minor as a DUI all the way to a murder. The question is going to be, what are going to be the benefits of accepting a plea versus going to trial? And that's assuming that the state, the DA, comes forward and actually has an opportunity for the person to take a plea. And the question is really not that straightforward. There are so many factors that have to be taken into consideration prior to an attorney giving a client good advice as to whether they should or should not take a plea. Now, some people, they have sort of a mind state. I see this a lot with criminal defendants, some of them, that this is all about principle. They have like, it's more of like a mentality that they're against the system. So like when they get arrested, they're against the cops, they're against the judge, they're against the state's attorney. They don't like think of it in the sense of like, how am I going to save myself? They think of it as like an adversarial process against these like administrative bodies that really don't view them as anything more than a number, quite frankly. One of the jobs of the attorney who's representing an individual like this is to, in fact, present that evidence showing that they are more than just a number, and that, you know, circumstances may have dictated whatever particular incident occurred that caused for them to be arrested in the first place. And I use a couple examples, particularly one that has to do with principles. Because when I'm representing a criminal defendant, I usually don't think too much about principles and, you know, whether they got railroaded or anything like that. Does it happen? Yeah, it does happen. But it's not something that is on the forefront of my mind when I'm advising my client and giving them my opinion as to how they should view a particular situation. And you would see, doing enough of this, that criminal defense is really not more than a cost-benefit analysis. That's really what it is. You weigh the costs of going to trial, not taking a plea, versus taking a plea, and what makes sense. And it's always coming down to particular aspects of the individual. What is their background like? That's a big question. You know, what are the consequences of a conviction versus a plea? There's so many different variables and things that can come up in a case, and that's why to talk about this, it's best to use an example and a couple stories I could tell about criminal defendants that I represented where we had to make a choice of to plea or not to plea. So in the first example, it's a little bit less of an ugly case, although it's still pretty ugly. But this individual, his sister had been dating a guy who was pretty abusive. He used to like beat her up, and it was pretty regular in the way that he beat her up. And I think on some level, I think that she was like sort of a willing participant. You know, obviously you don't want to do any like victim blaming, but the reality of it is that she stayed with this guy for like multiple years. And, you know, every time the cops would be called, he'd be arrested, and then she would drop the charges. And she also had certain aspects of her personality that I kind of felt were, I guess you could say, abrasive, to say the least, toward the system and the judges and the attorneys and everybody that was involved in the entire situation. So her brother, he eventually got fed up with this because his sister was getting, like, you know, pushed around by the boyfriend. And so the brother, he goes over to the house, and I mean, he beats the shit out of this guy. Like, bad. Like, he got charged with aggravated battery. He got charged with kidnapping and robbery. Because what they're saying was when the guy tried to get away from getting beat, they pulled him back into the house and continued to beat him. And they took his money, I guess. Those were the allegations that he was making, what he told the police after the fact. But he beat this guy so bad, he probably should have been charged with attempted murder, quite honestly. I mean, the guy had like a staple from like one ear all the way to the other, like fat staples in his head. And he probably did some brain damage. And, assuming the guy, had much brains to begin with, which I also tend to doubt, but he should have been charged with worse. He could have been charged with worse based on the nature of how bad he beat this guy. So, in any event, this particular client, he had a background. His background was terrible. He had, a background sheet about this thick, all kinds of gang activity, all kinds of arrests for drugs, other violent crimes. The worst thing was an attempted murder when it was a gang dispute. He rolled up to the car. He had a gun. He just like unloaded into the car, shot like 15 times, all over an insult. It was over like it was like a nothing. And he ended up going to try to kill this guy and a few others. And he ended up hitting one, but he didn't kill him. He was charged with attempted murder. He ended up doing like 12 or 15 years. So in any event, his background was certainly not doing him any favors in a case like this, where he just like brutally beat up the man who was beating his sister, and I guess you could say potentially deserved it himself, regardless. So as the case is going on, the state, oftentimes what happens, the case will start, the state will come with a high offer, and then they get lower and lower and lower. And then as the facts become more revealed in the case, the state starts looking at the nature of their own victim, and they realize that their own victim, he's probably not the best person to be testifying, putting on the stand either. So it got to the point where the state was literally willing to amend the charges, make them probationable, so he would not do a day in jail. And this particular client was, I'm telling him, what do you have to protect? You're already a multiple felon. You've been in jail multiple times before. The reality of it is, you did almost beat the guy to death. Whether it was, because of what he did to your sister, it's almost irrelevant. I mean, in fact, the state is going to use that as a motive as to why you did what you did. So it wasn't like a self-defense claim in the sense that he was attacked first and then he beats the guy nearly to death. It was, he just went over there to beat the guy up because he was avenging what happened to his sister. Any event, the judge was essentially on our client's side. He kind of understood the situation that this was not exactly the best victim, but at the same time, when the question was proposed to the judge, in the event that he's found guilty of any of these charges, the aggravated battery, the kidnapping, the robbery, what is the sentence going to look like? And the judge basically said he's looking at football numbers because he had such a bad background. He's been in jail so many times before. So his whole thing was, I'm not guilty. I'm not guilty. I'm going to trial. I'm going to put it in front of 12. He's doing all that whole thing. And meanwhile, I'm telling him, look, man, I get it. I understand your point. But the judge told me that if you lose somehow, you're getting football numbers. Are you willing to risk going to trial, going to jail for over a decade when you have probation on the table? What are you protecting? It wasn't even like this guy was like, no background and he was protecting himself from having a felony background. There was like almost nothing to protect and everything to lose, even though in his heart of hearts, he felt justified in doing what he was doing. So he told me, we're going to trial. We're going to trial. So basically, I said, okay, he's my client. It is what it is. You want to go to trial? We're going to go to trial. I could only, tell a guy so much before he's going to eventually have to make his own decision as to what my opinion is. And then The next day came. It was a status date on the court date, and cooler heads prevailed. And he decided, you know what, I'm gonna take your advice on this, and I'm going to plead guilty and take the probation, which he did, which was obviously a smart decision. If it wasn't a smart decision, I wouldn't have been telling him to do it. So that was one situation where you got a guy who is trying to not necessarily, he's thinking about the principle. I feel justified in what I did, so why would I plead guilty? Sometimes it's better to plead guilty even when you feel justified in what you did, even when there is some principle involved, because you don't want to go to jail for over 10 years over principles. And that's just the way it is. It's the way I see it, at least. Some people might disagree. Had another case, and this was an interesting one, a little bit more brutal, well, significantly more brutal. In this case, a person had been in a relationship with a woman who had a child. And for one reason or another, he had a beef with the child. I don't know what his problem was with the kid. The kid was young. He was only like 7 years old. And he did something to the kid. He hit the kid, and the mother filed for an order of protection against him on behalf of herself and the kid. And the judge granted it, obviously. He hit a kid. And what ended up happening was later was this individual had violated that order of protection. And while his ex-girlfriend and her child were gone from the house, he had broken into the house, and he had been lying in wait for them to come home. And when they came home, he had ambushed them. He did all kinds of weird stuff. It was like he tied the kid's hands up. He didn't do anything to the kid. He just tied his hands up. He like put him in another room. And then like he sat there with the ex-girlfriend. They were like talking for a couple hours. She was claiming he was forcing her to do drugs, forcing her to do cocaine, all kinds of weird stuff. Forced her to do, to have oral sex. It was just a really, really bizarre set of facts, to say the least. In any event, he somehow realizes what he had done was absolutely insane and that the police were going to be looking for him. So they issue a warrant for his arrest, and he was charged with violation of the order of protection. He was charged with child abuse for this situation, for just tying the child's hands together. He was charged with sexual assault for what he did on his former girlfriend. And I remember this case, it started like, I think his offer was 99 years. It was basically akin to a life sentence had he accepted that. So in a case like that, well, the reality is that you really should go to trial, because what is the point of accepting a 99-year plea? I mean, no matter how remote your chances of winning, if you just accept the plea, you're basically accepting a life sentence on a 99-year sentence in which they were, started out at the state in their offer. After, a couple years of him sitting inside, because the judge obviously was not giving him a bond at that time for the nature of the violation. I mean, it was egregious. It was disgusting. The state eventually came down to, it was a 25-year sentence that would cover the entire, it would be in total a 25-year sentence. And I remember, so on the date that he's supposed to enter this plea, okay, because I had numerous conversations with him about this. And I was like, telling him like, look, this is the reality. You go to trial, you lose, the judge is probably going to launch you. He was a younger man. He was about 25, 26 years old. So a 25-year sentence, 85%, he'd probably get out late 40s. That was what that's when he would have been able to eventually parole. Sure, he would have been on the sex offender registry for the rest of his life. Probably be damn near impossible for him to get a job or do anything like that after he gets out of prison. But the fact of the matter is, he would have a release date. The facts were stacked against him. There was a violation of an order of protection, and then there was a sexual assault whilst in the violation of that order of protection. So to take 25 years was the smartest thing, in my opinion, that this guy could have done. And I remember we're standing in front of the judge and we're ready to take the plea. And the judge asks him, how do you plea? Guilty or not guilty? And then he kind of just looks over at me. And I'm looking at him like this. And I just shrug my shoulders. I'm like, what are you going to do? Because I can't make the plea for him, So that would be like a grounds of appeal. He didn't actually say that he was guilty. So the way that I sort of took it with this guy is that he was so ashamed of himself and what he did that he didn't even want to say that he was guilty because he knew what he did was so shameful. It was so hard for him to say it. In fact, when he did say it, it was in such a muffled tone. He was like, guilty? Like that it's such an ashamed, muffled way that he pled guilty. So in any event, to plea or not to plea, there's a lot of factors and a lot of different things to take into consideration. A lot of it has to do with what do you already have in your background? What are you trying to protect? If you're already a multiple felon, what's another one? That's often a question, how old are you? Are you going to die in jail based on whatever sentence they offer? How good are your chances at trial, realistically? I see guys all the time, they want to nitpick at the smallest little details. The gun handle was brown and not black. Like that matters. See stuff like this all the time. So, like I was saying, to plea or not to plea, very often a cost-benefit analysis. And I'm very, very fortunate to have had the opportunity to do a lot of criminal work because I got such great experience in litigation. And I look forward to sharing some of these stories with you. So I hope you enjoyed this story. Like I said before, please subscribe. And I look forward to you checking out the platform. And have a great day. I hope you enjoy the content.